All right, and we're back. Welcome back, Select Committee. Welcome back, Mr. Co-Chairman.
Yes.
Our next item for consideration is our digital asset bill drafts. We've got a couple of things to consider this afternoon, and I know we've got some public interest on it. First up for our consideration is legislation that we requested at the last meeting, which is Wyoming Digital Asset Registration Act, 23 LSO 171 version 0.4. Ask Mr. Hopkinson to come out and walk us through the bill draft.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 23 LSO 171, Working Draft 4, Wyoming Digital Asset Registration Act. What this bill draft does is create a new article in our Wyoming Digital Assets statutes. And so all of the definitions in those digital assets apply, even they're not spelled out in this draft, but all of those would apply to this bill. What this bill does can be broken down in that first subsection A, and that's where you'll find kind of what it's accomplishing. And that provides that the lawful owner of any digital asset may register that asset with the secretary in accordance with this article, and that they shall be deemed to be located within the state for purposes of all laws and regulations of this state or any applicable federal laws not in conflict with this article and which may impact ownership rights or require transfer of the registered digital asset. So there's kind of what it does. The rest of it is dealing with specifics regarding and surrounding that, the registration process, applications, fees, that sort of thing. Much of this language is kind of borrowed and taken from our trademark statutes. Subsection B there then provides that the secretary shall provide a registration certificate cryptographically signed by the secretary for each registered digital asset, could be attached to or otherwise associated with that asset. Article 203 provides for the application and the filing fee, and provides that any person may submit an application in the form and containing information as prescribed by the secretary. And that form shall contain at least the name and address of the person applying or their business, if they're a business, the nature of the digital asset, and sufficient information to identify that asset. Provide a statement that the applicant is the lawful owner of the asset, and that to the knowledge of the applicant, no other person has a current valid registration of that digital asset, either in Wyoming or another jurisdiction. The application shall be signed and verified by oath or affirmation and subject to perjury. And the application shall be accompanied by a registration fee not to exceed $300. Upon the filing of that application, the secretary will examine that application for conformity with the article. They shall provide any additional information that the secretary may need and make any necessary amendments to that application as reasonably requested by the secretary. The secretary may revise the application with the agreement of the applicant or require that the applicant submit a revised application. If the applicant is found not to meet those registration requirements, the secretary shall advise them why. And the applicant shall have a reasonable period of time in which to reply or amend the application. And then that process would be repeated either until the secretary finally refuses registration of the digital asset or the applicant fails to reply or amend within a specified time period. Article 205 provides the term of registration and provides that a digital asset would be registered for 5 years from the date of that registration. And upon application within 6 months prior to the expiration, that term could be renewed for another 5 years. And the renewal fee would be $150. And then they can continue to renew that for additional subsequent periods as those come up. Article 206 provides that registration of a digital asset is assignable, and that fee would be $75. And that upon recording the assignment, secretary would issue a new certificate for the remainder of that term in the name of the assignee. And it also provides that an assignment of registration under this article shall be void as against any subsequent purchaser for valuable consideration who did not have notice unless the assignment is recorded prior to the subsequent purchase. Subsection B there, this simply provides for a change of name, that the person could file for a change of name with the Secretary of State, and that the secretaries could issue a new certificate for the remainder of that term as well. On page 8, 207 provides the secretary shall keep a for public examination, a record of all current registered digital assets under this article. And Article 208 then provides for the cancellation of that registration, that they would cancel, the secretary would cancel from the register any registration upon voluntary request for cancellation, any registration that is not renewed, any registration if a court of competent jurisdiction finds that the registrant is not the owner of the digital asset, that the registration was granted improperly or was obtained fraudulently, or the registration would be canceled anytime when a court of competent jurisdiction orders cancellation on any grounds. That staff comment on page 8 is just noting a policy decision here that as drafted, it would require cancellation of the registered digital asset and remove them from the public record. So the committee may wish to consider either leaving them in the public record or requiring the secretary to maintain a separate record of canceled assets. Article 209 provides for false or fraudulent representations, and just provides that any person who on behalf of themselves or another registers a digital asset under knowingly making false or fraudulent representations or declarations is liable to pay all damages sustained in consequence of that filing or registration to be recovered by or on behalf of the injured party in any court of competent jurisdiction. Article 210, the secretary outlines kind of the powers that the secretary has with respect to this, and that they have all powers reasonably necessary to perform the duties that this article would require. The secretary that would include promulgation of rules and regulations, setting and collecting registration, service and copying fees, providing that those fees do not exceed the cost of services. Section 2 on page 11 amends the Chancery Court statute, just providing that new language there at lines 18 through 21, that a dispute concerning a digital asset that's registered is something that the Chancery Court would have jurisdiction over. And it notes there that the monetary threshold required does not apply to actions under this paragraph. So a registered digital asset could be disputed or resolved within the Chancery Court. Section 3 requires the Secretary of State to promulgate rules not later than July 1st, 2023. And Section 4 has a split effective date, providing the act would be effective immediately with respect to Sections 3 and 4, the implementation or the rule requirements and the effective date. And then the remainder of the act would be July 1st, 2023. With that, I would stand for any questions on this bill.
Excellent. Thank you, Mr. Hutchinson. Any questions? Any questions on 23 LSO 171? So I have a couple. One, getting to page 4 at the top. As we contemplate that it can't be registered in another jurisdiction. So this seems a little bit unique relative to maybe how the trademarks would work, because we want clearly from the A paragraph right at the beginning to indicate that it's an asset that is, we'll say, property in Wyoming. The question I have would be from registration on any other jurisdiction, contemplating a federal registry where the state of Wyoming is within the federal registry, they could potentially have a registration in, whether that ends up being something like USPTO or elsewhere. Would this contemplate that? It doesn't seem like it would, and it seems like we might need to tweak it a little bit if we wanted to allow for the fact that it can be owned as an asset in the United States, governed by US law, and also further refined down to an asset within the state of Wyoming. Thoughts on that?
Thank you, Mr. Chairman. Certainly, I think that's a policy question. As drafted, I would agree that this would not contemplate registration federally as well as through the state.
And I guess I'm not sure whether we would need that. Again, with property, we have digital asset as a class of property. That property is, according to this, registered as a Wyoming bit of property. I'm trying to think through whether we would need that clarification or whether the language that we have here would be sufficient, even if there were a federal registry. I don't know if anyone else has any thoughts on that, but something to contemplate. All right, won't put anyone on the spot for that, but and then David, I think that's something that we at least need to think through. And I don't know whether that's something that we'll have to change or not. All right. The other question on page 6 and on to page 7, the assignment of registration and change of name. We talk about a digital signature for the registration earlier, and I think this language and assignment language is, if I'm not mistaken, mirrored from the trademark language and trademark statute. Based on the other language and statute, I would be inclined to believe that this already would anticipate transactions through digital signatures, any type of electronic transaction, smart contract, partial ownership, anything along those lines, I think would already probably be accounted for elsewhere in statute. But wanted to get your thoughts on whether we need to be explicit in these couple of paragraphs talking about registration and assignment, or whether we feel like we're in a good place and that that's going to be covered based on our prior statutory work. Mr. Hopkinson, thoughts?
Mr. Chairman, in looking at what the draft does, requiring the secretary to accept as this registration, I don't know that existing statute would require any notification to the secretary about any change in that ownership. Certainly, I think a party could cancel their registration and then sell the asset, and that new owner could register it. But I don't know that existing statutes really account for that transfer in ownership of the registration. But certainly if the Secretary of State's office has a different opinion on that, that I would defer to them.
And Mr. Hopkinson, I guess more accurately, the assignment of registration that we have on page 7, lines 8 and 9, I guess is more what I was anticipating, how that assignment would be carried out, where if this were a digital asset and we had a Wyoming registered digital asset, my expectation of the way an assignment would be carried out, whether it's temporary or however it ends up going, would be through some sort of a smart contract transaction, something along those lines, or well, anything that's going to be algorithmic, electronic, and require probably some signatures, public-private signatures. I don't know that we need to be explicit, but that's where my concern is, to ensure that it would be acknowledged and valid, and that there's an understanding that process would be a legal transaction. I think all of our electronic contract language previously probably makes that clear, but that was what I wanted to check into, whether we needed to strengthen that or whether we're sufficient to mirror the language from the trademark legislation.
Mr. Chairman, I don't have a good answer.
No, that's
for you
fine.
now.
That's fine. These are just some things that, and maybe Representative Stith, I don't know if you've had a chance to kind of look at that language and think about it. That was something I just wanted to ensure that everyone was comfortable with. Page 7 or bottom of page 6 and onto page 7, the language related to assignment of this Wyoming registered digital asset. Whether 6 onto 7 would be sufficient language or whether we need to get more into the technical weeds.
Mr. Chairman,
Go ahead.
if I understand it, the purpose here is essentially we're creating a kind of chain of title for digital assets that will be independent of whatever blockchain that the assets otherwise exist upon. And I guess the real question, I suppose, is what the administrative burden to the Secretary of State's office would be from this. Is this going to be a substantial burden, or will it be something they can automate? But it seems the language itself here, if the purpose is to establish a kind of chain of title, with the kicker being that if you did register and you don't get to sell it twice to the same person, right? So that provides a level of protection. It'd be interesting to hear from the industry what the value added for them of that is, if any. Also, that's my understanding. To me, this language would accomplish that purpose.
Okay, thanks. Senator, did you have a thought? No. Okay,
Just
go ahead.
briefly, Mr. Co-Chairman, thank you, and to Representative Stith. Do you think that we should provide that process in statute as opposed to rule?
Representative Stith, thoughts?
Mr. Chairman, I think the legislature should make the laws. Yeah.
Right?
And there are practical ways in which you would expect this to be carried out with a digital asset. And I guess the key is just to ensure that the practicality of it would align with what we have here and what would be done. So I guess that's something to chat with the Secretary of State's office about. Any other questions at this time for Mr. Hopkinson, Mr. Co-Chairman? Any thoughts? No? Okay. Well, with that, let's move to public testimony at this point in time. And I had next Blockchain Commons to talk a little bit about it. Do we have Blockchain Commons handy? And then certainly want to hear from other public comment as well as the Secretary of State's office.
I'm here.
All right. I see Mr. Allen up there. Good to see you. And please introduce yourself to the committee. Welcome. Always good to have you here. We appreciate your help as usual.
Thank you. Committee chairs, members of the Wyoming Legislative Select Committee, and of course, the hardworking members of the Wyoming LSO office, who I greatly appreciate their work on all of this. Thank you for having me back to talk about the future of digital assets in Wyoming. My name is Christopher Allen, and I'm the founder of Blockchain Commons, a blockchain infrastructure development and research organization, which is domiciled in Cheyenne. I am also the co-author of TLS, the broadest deployed security standard in the world, and I am co-author of the recently ratified W3C decentralized identifier specification. So I'm a technologist. I'm coming at this from that perspective. I also represent broader communities of secure wallet developers who are, creating the wallets that will hold these digital assets. And these include silicon chip companies, hardware developers, and cryptographers. And I'm particularly advocating for no vendor lock-in and interoperability and, any of those kinds of problems that lead to centralization. I'm a leader in the decentralized identity standards area, and I'm heading off tomorrow to rebooting Web of Trust in The Hague, where we're kicking off some major new efforts to unite wallet standards in the EU around things like digital assets. So this is very apropos. I also wrote this, if you've heard the term self-sovereignty, I wrote the 10 principles of self-sovereign identity, which is largely what the community has been using and leveraging to try to say, this fancy dance that we have between, well, we need parties like the Department of State to say, hey, you can do this under Wyoming law. That's a natural centrality. but not let that become something that, locks everybody down to not have any choices at all, or maybe lets it such that, the only person who can talk with this Wyoming Secretary of State is Google. So you have to run everything through Google or some Google standard or whatever. We want to avoid those things. So that's kind of my role here. Specifically, I wanted to talk about one technical thing and then one process thing. So the technical thing is there is a single, I had it in front of me a second ago. It's in application for registration and filing fee 3429-203 section A2. The nature of the digital asset and sufficient information to identify the digital asset. I believe that that's insufficient from a modern security point of view. They need to demonstrate that they have control of that asset, which is pretty trivial to do. All the new emerging standards, DIDs, CIDs, you can do this with Ethereum contracts, you can do this with DAOs. You can create these proofs that they basically demonstrate that the parties who are contributing and asking for this registration actually have control. Otherwise, you're in situations to be comparable to somebody seeing your driver's license as you drive by and then basically registering your car to them or something of that nature, even though you don't actually, they're not at the driver's seat. We want to know who, somebody to prove that they're at the driver's seat. And there are a couple of ways you can do this. I happen to like something there. I think somebody has circulated something that has something called CIDs, which are common identifiers, or there's a couple of all roughly the same things, but there's also this idea of self-certifying identifiers. So all I ask is that this be amended. I think the language should be fairly simple to allow rulemaking to determine more, but I do believe that they have to demonstrate that they have control of the asset in that registration process. So that's my technical point. My process point that I really wanted to go over is, we have a history here that, we had registration of a particular kind of digital asset, a company, 4 years ago that has been stalled and is not actively deployed in a fashion that is competitive with what other now countries are doing, even though we funded it first, we enabled it first. So I'd really like to figure out how we can not lock this 100% into the Secretary of State's office to puzzle this all through. And maybe there needs to be some kind of companion enabling legislation to say, hey, they're allowed to charter with 2 service companies who will do the majority of this work in parallel, so that they kind of compete with each other, but they all, just like you have multiple registrars that are out there and they all compete with each other on service, et cetera, that you have registrars that are out there who can help with the Digital Registration Act and do the certification, do all the final steps. And then they basically say, hey, here is our presentation, including our, research that it's self-certified or meets your requirements or whatever, and here's the fee, and then you take it. I recommend you, try to as much make it that the Secretary of State does as little as possible, other than making the requirements for how these parties have to do what they do. Because otherwise it's going to be another 4 years. And I am talking, we'll be in The Hague this week, and they are talking about similar types of things around registration under EU. There's a it's like 20, 30 million, $40 million funded electronic self-sovereign identity wallet research going on right now. We have like 60 companies that are going to be showing up to my event, and this is one of the topics there. So I don't want Wyoming to get behind, because in the end, you can't process these. I have a lot of other minor comments, but those are my big ones, and I'll leave it to others to do things. But I'll be available during the rest of this session, and of course, anybody can contact me after if you'd like to talk about other issues. Thank you very much for your time.
Mr. Allen, thank you so much, and really appreciate your feedback as always and your insight in this area. In particular, the suggestions that you bring forward with some language changes, I think we can quickly remedy those, as well as thoughtfulness on coming up with an approach that allows us to really get this done where we've struggled in the past. So in particular, so just to check this language while we have you here on page 3, paragraph A, Romanet 2, where you raised a concern about the word identify. The language that is here and potential amendment would say the nature of the digital asset and sufficient information to strike identify and insert demonstrate control of the digital asset. So it would read the nature of the digital asset and sufficient information to demonstrate control of the digital asset. Does that meet that interest that you expressed? You're muted right now, I think, Mr. Allen.
Sorry, yes, I believe that meets the interest. I want to distinguish this from the nature of the paragraph after it, because the paragraph after it is that the applicant is the lawful owner and, that type of thing. I think that's, more of a law question rather than a digital question. And, you may have control of an asset, and it should be easy to digitally demonstrate that. But there, may be other parties that say, oh, wait a second, we have a lien on that asset or other different messes. But if you can demonstrate control, that should be the first step.
Perfect. Thank you so much. All right. Any questions for Mr. Allen? Any questions? Seeing none. Thank you so much. Stick around in case we have some more questions and need to work on this language a little bit.
Will do.
Okay. With that, Mr. Co-Chairman, if we can take a quick pause. I know that we have Commissioner Feldman here from the Consumer Product Safety Council, and appreciate having you and visiting Laramie, coming to join the hackathon and the Stampede activities. And I'd like to welcome you up with your staff, and Mr. Lupin wants to join. I know that he's hosting. Please come up here and we'll give you a few minutes to tell us your thoughts in this space. We know that you're deeply involved and following all of our endeavors and the endeavors around the country to ensure that we have some consumer protection hopefully in place as we're moving down this exciting path. So welcome. Please introduce yourself to the committee, and the floor is yours.
Thank you, Senator and Representative Olson and members of the Select Committee. Good afternoon. Thank you for that introduction. First, I want to thank the Select Committee for inviting me here today, and I also want to thank in particular Mr. Stephen Lupian for his assistance in arranging my appearance today. Before I get started, I also want to recognize my staffer, Tommy Fuller, who's joining me here today. I believe joining remotely and watching all of this is also my chief counsel, Doug Ziak. Both Doug and Tommy both worked for the late Senator Mike Enzi. Doug first as his legislative director and then as a budget committee staff director until Senator Enzi's retirement. So the Wyoming connection here is a longstanding one. And Tommy served as Senator Enzi's counsel on the Senate Budget Committee. I want to provide some background about my earlier government service. I joined the United States Consumer Product Safety Commission, or the CPSC, in 2018 as a commissioner. Before that, I served as chief advisor to then Senate Commerce Committee Chairman John Thune from South Dakota on policy and legislation and congressional investigations. I know that one of the important things that I learned from both Senator Thune, Senator Enzi, and others that I've worked for, is that there's a lot of common sense ideas that are coming from outside of Washington, D.C., and we need to make it a priority to travel outside of the Beltway to learn. So I come here with some humility. There's only so much of this job that I'm able to do from behind my desk in Washington, D.C. And I believe that it's critical that regulators do get outside of Washington from time to time to hear directly from stakeholders, to stay abreast of developments and trends and changes in consumer preferences, compliance, and the like. It's important to recognize that we don't have all the answers, and there's just a lot that we can gain by coming and listening and learning. And that's why I'm here. That's why I'm excited that we get the opportunity to participate in the blockchain stampede and the hackathon. Because it does touch on a number of the issues that the United States Consumer Product Safety Commission faces. It's my goal to return to DC with some innovative ideas that can help my small agency effectuate its mission more effectively. And CPSC, it's an independent agency with its primary offices and its laboratory just outside of Washington in Bethesda, Maryland. And like other independent agencies, for instance, the the CFTC, the Securities and Exchange Commission, the Federal Trade Commission, we are a commission of 5 members that are presidentially nominated and Senate confirmed. And our mission is simple. It's to save lives and to keep families safe by reducing the unreasonable risk of injury associated with consumer products in commerce. We have jurisdiction over hundreds of thousands of products, with the notable exception of automobiles, drugs, and financial products. So it's not that aspect of cryptocurrency that we're interested in. But in practical terms, we're the agency that works with manufacturers, distributors, retailers, and the like to make sure that unreasonably unsafe products don't make it to your homes. And if they do, that we're the agency that effectuates the recall. So if at some point, if you've received a letter about a product that you own or seen an email or seen a recall posting at a retail store, it's probably us that was on the back end of that. So given our mission to inform consumers about recalls, I would be remiss if I didn't take the chance to plug our agency's outreach efforts so that everybody can stay abreast of consumer recalls. Of course, you can sign up for these alerts at www.cpsc.gov to not only receive alerts about what's going on, but to report issues with products that you may be aware of. And I believe that markets generally work, but sometimes there are actors that are competing unfairly and skirting the rules and not paying attention to the testing and certification requirements that we do enforce. And we have teams that are dedicated to addressing those issues and going after those bad actors. I also think it's important that companies interact with us, not because they're doing anything nefarious, but because from time to time mistakes happen, issues arise. That's why we're here. And from time to time, it's that collaborative approach that really does bear fruit. So even with a cooperative relationship with the private sector, we're not as effective as we need to be in terms of effectuating consumer product safety recalls. The Government Accountability Office put together a report in 2019 noting our challenges with recall effectiveness and setting forward a series of recommendations to improve our ability to execute that part of our mission. And these are important recommendations, but I do view it as a first step, and there's a lot more that does need to be done. And that's frankly why I'm here at the conference. I want to learn and brainstorm about how we can leverage innovative technologies to improve recall effectiveness. I think there are a number of longstanding skills gaps at the agency that I've worked to close in terms of hiring a chief technologist and a chief data analytics officer that has done much in terms of improving our expertise in the area of the Internet of Things. I think through that, we've experienced some firsts with a recall 2 years ago involving a Peloton bicycle, where we were able to upload direct to consumers via an IoT device a recall notice that did experience a higher level of recall effectiveness than we might otherwise expect to see. But it's instances like this and other articles that I've read that excite me about the potential for blockchain. And what I've learned so far, I'll admit I'm much further behind the curve than you all are. What you've done here in Wyoming is impressive, and the rest of the country and the world is watching. And it's not surprising that this is a technology that's being used in terms of food traceability and recalls that involve agricultural products. In that respect, You've been a first mover in using this technology to help improve recall effectiveness. I recall back to the recent romaine lettuce recall, where they were able to trace to the hectare where the tainted product was coming from, and rather than pulling everything from the shelves across the board, going specifically to where the tainted product was and doing that in a targeted, effective way, that worked. As I mentioned earlier, CPSC doesn't conduct food and drug recalls, which are the subject and jurisdiction of the FDA, but being able to trace food back to a particular hectare of land or a specific animal is better for consumers and producers. We recognize that, and I believe that probably holds true for what we do. And I'd like to work with manufacturers, distributors, and retail sellers of products to figure out how we can leverage technology to get those insights into the supply chain and improve what we do in terms of consumer product recalls. A narrower, more target recalls is gonna work better, as will sort of that specific targeted notice to consumers. It's more likely to be listened to and acted upon. And these are the improvements that I'm excited about. So in closing, I'm here to learn and listen. I want to thank you all for allowing me to be here today. I encourage you to work with those in industry and families and others that are stakeholders of this select committee to help keep consumers safe with a consensus solution. In the meantime, I'm going to continue to push to modernize and increase transparency at my agency back in Washington. But again, thank you for your leadership on this technology. It's having real effects in terms of keeping people safe. I think that there's more we can do. Let's figure out what that is. With that, thank you very much.
Thank you so much, Commissioner Feldman. We're really happy to hear those words and happy to have you here. We're also very happy to hear the ties that you have to Senator Enzi and all of his quality work on behalf of the state of Wyoming over the years. It's heartening to hear that you have folks from his staff on your staff now. We look forward to working with you, and we would avail ourselves to that anytime that you need to maybe understand what we're contemplating and some of the ideas that we're hearing from the community. I'm sure that you're aware that we've focused heavily on consumer protections through all the legislation that we've put forward over the years, and have really worked hard to make sure that we're not creating implementation or use cases that end up poisoning this space or leading to bad outcomes. We want to ensure that we're doing things right the first time, and as a trailblazing state that is first of its kind in a lot of this legislation, that means that we have to work 3-4 times harder than anybody else that's doing the copy and paste business to try and get things right. So if you hear anything or learn of anything that we need to be aware of, we'd appreciate hearing that, and we'll have that same relationship. We'll reach out. Committee, any questions? Representative Ian, go ahead.
Thank you, Mr. Chairman. Commissioner Feldman, I very much appreciate you coming here, taking the tour. I think if more agency heads and commissions did the same thing that you'd be doing, a lot of people would have more confidence in what the federal government does in general, and that you're doing the right thing. And I just want to applaud you for doing that. I do also want to
Thank you.
I also want to applaud the for such a small agency, the work of Joseph Galbo, which I believe is your social media specialist. I think he reaches out to a whole generation of people that wouldn't normally be following CPSC on Twitter, right? And so I think even we have something to learn from you guys. And so I do appreciate the both the work that you are doing and the work and the tour that you're taking now, and the work that your agency does.
I appreciate those words. Thank you, Representative.
Any other questions for Commissioner Feldman? No. Seeing none, thank you so much. We hope you'll stick around with us for a little while. And
I will, Senator. Thank you.
Yeah, if you have anything else to add, please join us.
And Mr. Chairman, if you haven't
ahead.
seen the CPSC Twitter, you should go on the CPSC
All right,
Twitter.
time to follow. Thank you. All right, getting back to our 23 LSO 171 bill draft. For those that are recently joining, Wyoming Digital Asset Registration Act that we've been discussing. I'd like to go to public comment, and in particular, I'd like to invite the Secretary of State's office to come up and talk us through how this might be implemented and maybe address some of the concepts that we've been discussing and with Mr. Allen about how we can assure that this is effectuated and how we might work through those concepts. Welcome back. Please introduce yourself.
Thank you, Mr. Chairman, members of the committee. Karen Wheeler, Deputy Secretary of State. And Mr. Chairman, we reviewed this bill in the office solely from the perspective of the filing agency, where this would be built and where it would be filed. So I will go through and discuss a little of the comments that we have. And I do appreciate that Mr. Hopkins did this, modeled it after the Trademark Act, because it's not a new entity type, but it seems to mirror what the trademarks do when they're filed in our office. So with that, Mr. Chairman, looking at it solely from the perspective of filing it within our office, the first comments that I have, first of all, talk about the fees. You will see it in various sections. The fee is not to exceed a certain amount. That does mirror the Trademark Act that we have. The rules that we have in place for the trademarks define the fees. So we do have those set in rules as well. And we could certainly mirror those or set the fees at whatever the committee would like. Now on page 4, section 3429-204. This has to do with the examination of the application. So when a trademark is filed with our office, it's very important that it have one of our registrars review it, make sure that it does not conflict with an existing trademark that is registered with us. Particularly, we watch very closely for the bucking horse and rider, as our office does own the federal trademark on that. In this particular instance with the digital asset, as this is voluntary, it's not a mandated filing. We had two thoughts. Number one, because the application is pretty clear as to what is to be on it. If we do this where we have to examine it, it's going to put it in a queue until one of our registrars can get to it, and it must be filed within 15 days statutorily. If it does not have to be reviewed by our office, then it could automatically be filed as it is when you file an LLC online. It does not go into a queue, it's automatic. So that would be the first comment we have on this for the committee to consider whether or not you want it to be, the application to be reviewed or automatically filed. Next, Mr. Chairman. Again, I've just looked at the renewal process that is identical to the trademarks. Again, the fee for renewal is set by
Deputy,
rule.
I'm sorry to
Yes.
interrupt and rewind just for a moment. I
Sure.
was trying to glean from that comment what the best way to effectuate that would be. And I was looking at striking paragraphs. Clearly paragraph A, but then did you contemplate what it would look like if we were striking the language that required it to be reviewed, have an automatic entry and not have that queue? Would it be A, B, and C that go away, or do you not have specifics there, Deputy?
Mr. Chairman, I don't really have specifics.
That's okay. Please continue. We can figure that out. I see your point. Thank you.
Thank you, Mr. Chairman. Again, it's just looking through pages 6 through 7. I only made notation of the fees. Again, happy to set them by rule if you would like. On page 8, section 3429-207, and the staff comment in the Secretary of State's office, whether a trademark's canceled or a business entity is dissolved, withdrawn, we don't remove them from public record. They stay. So I would suggest that we do keep the same language that we have in the Trademark Act, that it does stay in the public record. 3429-208, this was an interesting one for us, both internally and looking at the trademarks that are filed with us, and also for this particular registry. And I guess first question I have is, how can an asset be canceled in part? And so I asked that question of our business division. How is a trademark canceled in part? And I spoke with the business division director, who has been there for 32 years. And she said, never has one been canceled in part. And we only have 9 cancellations of record.
Wow.
So
Okay.
I would ask just to think about that, how we would cancel it in part. I believe the Trademark Act was originally written in 1957 or 56 and updated in 1997. So I don't know if this is original language, what the intent was, but I'm not sure how we do a partial cancellation.
What happens in that circumstance if you have somebody registering a trademark? Again, we're going back to the trademark law, where we'll say half of this trademark design is the bucking horse and rider, and the other half is something entirely novel. So you're obviously going to say, no, you can't use the bucking horse and rider. The rest of it is just fine. You've got an application process here, so I assume that conversation is how it would go. You would have that conversation, and then they would revise and then resubmit. Is that fair?
That is correct, Mr. Chairman. It is a deviated mark, and we do not allow a deviated mark of the bucking horse. So we'd ask them to remove it and resubmit the application.
Okay, and in a circumstance, going back to the concept where we don't necessarily review it, but we'll say that I submit digitally as an asset, something which is 50% not something I'm entitled to. It turns out that there's this prior existing art, but the other half is novel. I think we would want a circumstance, I'm just projecting here, guessing that we would want a circumstance where there would be some sort of a severability where it doesn't void the entirety of the registration. You'd have survival of the novel digital asset potentially as a concept. Is that a circumstance where in whole or in part might be necessary to have there? I mean, maybe it's a different use case, and maybe there are scenarios that would fall outside of what we've done in the past. What are your thoughts on that?
Mr. Chairman, I guess I would defer to the committee and the industry.
Okay.
As to how we might accomplish that, or if that is something that you want to do. If it is, we could certainly work on the language and how to affect that within our system.
What would happen in a circumstance now where you've done your review, you cleared it because you didn't see any internal conflicts? Somebody comes along later and probably through a court challenge or maybe just a challenge within the Secretary of State's office says, no, the left half of that is my my property, my trademark. Would you currently do effectively a severable approach where you eliminate that which was objected to and keep the rest, or is that not something that comes up?
Mr. Chairman, that honestly does not come up.
Okay.
I hope you didn't just jinx that.
Yeah, right. Thank you, Deputy. Sorry for those questions.
okay.
Go ahead. Please continue.
Okay, thank you, Mr. Chairman. So again, 3429-208, again, I would just ask that we have discussion on that as we just did. And Mr. Chairman, then the next, actually only other item I have is the effective date on page 12, section 4 of July 1st of 2023. This would be, and this isn't my last comment, I guess, because we do have a fiscal impact. This would be creating a whole new module within our system. And I am assuming that the committee would like this to be an online module and have these filings done online and not in paper form. So to be fair to the staff, that there could be some attrition by the end of the year. If we could make the effective date October 1st, I don't want to put something on the staff that they cannot meet, nor in fairness to an incoming secretary, something that they could not meet as well.
Great. And getting back to Mr. Allen's point about ways that we could potentially structure this to give more flexibility to the Secretary of State's office to implement it, maybe use an outside provider, an API developer. We've talked about this before in other circumstances. Do you have any ideas on maybe a section for outsourcing or something along those lines by MOU, by contract, that if the Secretary of State deemed it was more expeditious, they could outsource this instead of doing it in-house? And I guess I would ask, could you do that right now with the trademark program that's currently in statute, if you wanted to hand that over to an entity that you supervised instead of directly taking action, would that be allowed under the statute?
So, Mr. Chairman, the biking horse and rider statute is completely different than this, and we do have an MOU with the University of Wyoming for the enforcement of the protection of the mark. To do this, and I certainly understand where Mr. Allen is coming from, to do an online portal the way the law is written right now, I have been assured by our technology division, they can have it in place by October 1st. If you want to outsource it to a third party, we would have to go through an RFP process, which could take months, and then to approve it and then to do the requirements. I'm not sure that it would be done before October 1st. So I guess it would be up to the committee which way you want it to go.
But there is confidence that this could be up and running by October 1st through an electronic online filing system.
The way it is written now, and if this goes forward to the next meeting, whichever, I will assure you, the way it is written by the end of the year, we will be able to implement it. Now, if a considerable amount is added to this, it might delay the effective date, it might enhance the fiscal impact, but as it is written today, yes, it can be implemented with an online function by October 1st.
Great. Thank you. Any further questions on that? And Deputy Wheeler, was that the last point you wanted to make here? And I see Representative Stith has a question. So I'll just go to Representative Stith and then we'll come back to you. Representative Stith.
Mr. Chairman, Ms. Wheeler, thank you for being here. I wanted to go back to your suggestion concerning automating the filing rather than having it be each application be examined. And I just wanted to have you kind of walk us through what that would look like if we automated it. So right now, if someone applies for a trademark and they want their trademark to be Ford Motor Company, that gets examined, and presumably your office would likely, assuming that it's not coming from the actual Ford Motor Company, your office might reject that and send it back to the applicant and say, we think you have a problem, I would think. If someone wants to register as a digital asset, the domain name fordmotorcompany.io or something, if you automated the process, would you still be able to catch that? Or if you do it manually and you have manual examinations, what would the scope, how would that play out for people examining a digital asset to see if this person really does own this particular digital asset? I mean, it seems like that could get messy for the office.
Deputy Wheeler.
Thank you, Mr. Chairman, Representative Stith. So right now, trademarks are filed in our office via paper form. It's not an online function. We don't have that many. So we have one registrar who is assigned to processing those, reviewing those. Our application forms, you have to denote whether it's a federal trademark or not. If there was one that was duplicative, we would obviously catch it. We would return it again. It's just like all of our other filings. You have 15 days in which we must reject or file. To file a digital asset online, there would be no review. However, the person submitting it is signing under oath according to the statutes or the legislation as written now. And that's what we would rely on. Not knowing the volume that we could get, and I have a feeling we could get a pretty significant volume of digital asset registrations. If you were to do it manually in paper form, I would think that would require, I don't think I'm quite positive, that would require additional staff. Our business division has, including the director of staff of 11, and they process right now 117,000 pieces of paper a year. They have over 4,000 phone calls a month and 5 email addresses they must respond to. So we would need additional staff if we were to do it manually.
Representative Stith, any follow-up? And ideally on that, we could get to a point, which we're probably not at right now, where you had some sort of a little AI engine that was analyzing whatever it was and then analyzing that against what's in the database and maybe giving back a little feedback in an automated fashion saying, hey, this looks a lot like this. That's very plausible. And again, there are advanced algorithms. You think about the fact that you've got fast Fourier transform algorithms going on when this is listening to music, it knows what it's hearing, right? The same kind of technology. You just do multi-dimensional FFTs against whatever is in your database, and if the fingerprint picks it up, it looks good. So that's out there. But again, we would not, if we had to get to the point where humans were sifting through paper, that's with digital assets, that's going to be a true nightmare. So I think that we do need to be thoughtful about the idea that we're being incredibly vague intentionally on what a digital asset is for registration. Because we want a wide variety of possible use cases. So I can't even fathom how somebody on a staff would be able to really go through and do that by hand. It's a valuable point. Anything else? Any other questions? And anything else, Deputy Wheeler, that you want to call to our attention on this draft?
Mr. Chairman, just the fiscal impact. The fiscal impact on that to build the new online module would be 248,400.
Thanks. And Deputy, you said that that doesn't require any sort of an RFP. That's already under existing contract and capabilities. So that is the cost, and we can have confidence in that number getting us to the finish line. Okay.
That is correct, Mr. Chairman.
Excellent. Additional questions? All right. Seeing none. Thank you, Deputy Wheeler. Appreciate it. Mr. Co-Chairman has a question. After you've
Sorry,
walked
Deputy.
all the way back over there, Deputy Wheeler.
I
Co-Chairman.
don't know if I'm gonna go down a tangent, but
Yes, you are. Hit
I
it.
probably am.
Let's do this.
Just looking at the statute on the bucking horse and rider, I wasn't familiar with this, but the statute directs that any fees off of licensing, royalties, revenues, et cetera, are deposited into a separate account.
Mr. Chairman, Mr. Co-Chairman, that is correct.
Okay, and what does the Secretary of State's office use that account for?
Mr. Chairman, that actually is an account that is within the University of Wyoming for enforcement. The
For-
Secretary of State's office receives $5,000 a biennium to use in the marketing of the mark, but the protection and enforcement account is with the University of Wyoming.
Uh-huh. Okay.
Further questions?
Well, I was just, I guess what I was thinking about was the cost to implement this, since there will be, I'm assuming, is there some type of, if the trademark has to have the license, has to have the buck and rider on it, then is there an additional, is there an additional assessment of fee for that licensing? For the individual who holds the digital asset?
So, Mr. Chairman, are we talking the digital assets or the bucking horse and rider?
Well, I thought this legislation would require a buck and rider on the, on the certificate. Is that not in here?
Did we not include the Lincomb loophole?
It's not in here, no.
I don't think it's in here. So you want to put that on?
Well, I just thought if it was in here, if it were in here, then there would be a pool of money, but I didn't realize all of that was spent for enforcement. And I thought that was in here. Now I'm sorely disappointed.
I'm sorry, we
in
can,
this bill.
we'll, there's an amendment. We'll get that.
Okay,
We'll get that. I don't know how we'll work it in. Everything has to have a steamboat on it. Yeah, exactly. It's good for amendment. Any further questions?
no, but I think Representative Stith.
Representative Stitt.
Mr. Chairman, to continue down,
Go ahead.
Mr. Chairman, to continue the rabbit hole. Ms. Wheeler, the trademark revenue generated with the bucking horse and rider, it all goes into an account that's used just for enforcement at the University of Wyoming? Did I misunderstand that?
Thank you, Mr. Chairman, Representative. Yes, it goes into an enforcement account. It's based on royalties, depending on whether of a use agreement or a service agreement. And I don't have my bucking horse and rider notebook with me today, or I'd be able to tell you what those royalties are.
Mr. Chairman, that's it, but it's a significant amount each year. I'm surprised that they would need that much money for enforcement each year.
Mr. Chairman, Representative, we've had some pretty significant cases in the past protecting the mark that high schools in other states have used.
Thank you.
Thank you, Mr. Chairman.
is this not doing its, there we go. It seems to have come back on. I hear myself. Any further public comment on 23 LSO 171, Wyoming Digital Asset Registration?
Mr.
Act?
Chairman,
Mhm.
we have Brendan Marr and Christopher Allen.
Got them both? Okay. All right, let's bring them both in at the same time. That's just fine. And we'll go to Mr. Marr first. And let Mr. Allen back clean up.
Oh, wonderful. Great.
Mr. Marr, hello. Please state your name for the record and welcome.
That's great. Can everybody hear and see me?
We can.
Oh, great. Wonderful. Yes, my name is Brendan Marr. I am a MIT Media Laboratory alumnus. I'm on the working groups. I'm a computer scientist. I'm on the working groups for digital identity, the DAO working group, as well as the data privacy working group. I have a number of comments. First, I'd like to say my comments will be to the point because these are somewhat prepared. I want to say first off, I have a general comment and then specific questions and statements that would be in the number of 3 regarding the actual draft of the legislation. So my first general comment is that I emphatically support the bill with one change. I'm really, really glad to see that the use of cryptographic signatures and public keys and signing by the Secretary of State is being put into this draft. That is a tremendous step forward. But I do have some questions regarding the bill draft itself. So my first question and then statement and then question is regarding a section on page 3, section 34-29-202B, where it talks about a registration of a digital asset for the secretary, and then it goes on to say for each registered digital asset. It's not clear to me whether that means that this is a certificate for a basket of digital assets or for one single digital asset. If I could have some clarity on that, that would be really helpful. And then I have a few other statements and questions. Thanks.
So I don't know that we can expressly delineate those because you can always put as much in the basket as you want and then register it as a unique digital asset. So I think the way it's structured, Mr. Marr, is suitable, which is that if you're delineating them as individual digital assets, then it's an each. If you decide that you don't want to pay the filing fee 3 times and you just kludge 9 gifts together and file it as a digital asset, I don't know that we would do anything to stop you from doing that. And it would then have one key and one transferability. It might cause you some complication if you wanted to do anything with one of them and not with the other 8. If you were trying to monetize it, you'd struggle. But again, the way it's structured is to not care. What are your thoughts on that?
My thoughts on that are, well, that is wonderful because then you can effectively register 300 at a time and pay $1 each. So that's very nice. But to the affecting segregation between them as individual assets, I do have some suggestions on that, which I will get to in my next second question and statement. So, and it goes to what was brought up, and I'd like to address a little bit what was asked regarding the questions that Representative Sith had regarding assignment and burden and, can you sell it twice? Where's the registry? These kinds of issues. And also Senator Nethercott brought up these same kinds of things. So the statute language in the draft is 34-29-204, affecting a control. Well, it's regarding affecting control or transfer. But the actual statute section is 34-29-204, examination of application of amendment of the application. So what is missing from this is the idea, as Christopher Allen has mentioned, the cryptographic keys of the holder. And I don't see any place to put that. This is actually really important. And it gets to a small little act. We actually kind of solved this problem before in the Digital Identity Act, because the Digital Identity Act was specifically written for this reason. It was written with the language, we put the language in the Digital Identity Act to contain the phrasing, I'm paraphrasing here, but demonstration of principal authority. The question is how? And as Christopher Allen had suggested earlier, that demonstration is through cryptographically signing, resulting in a digital signature, a cryptographic signature, which is one set of bits, one field, and then you have to have the corresponding public key associated with that to make sense of it. And then you have the document, in this case, the certificate. So there's three things. Three things. So what's needed is not only the cryptographic signature and key of the Secretary of State, you actually need to include those of the holder of the certificate. And the reason why you have to do that here is because you actually don't have a registration of a blockchain. And this gets to Representative Sis' question and statement about selling it twice. Right, on a blockchain, you don't have that problem, because the blockchain is the registry that is both sides of the market, right? Here, you don't have both sides of the market. And this is why there is a problem. Because what you're trying to do is you're trying to represent both sides of the market with only one set of keys. And this goes to a very, very important point regarding how is this affected in terms of statute or through the Secretary of State. And the very, very important questions that were raised in terms of solving, throughput. And I want to address that and how we do this, but I do want to pause because I don't want to talk off the rails. I'm sure there are many questions at this point, but I have a solution for you, and I want to pass that along.
All right. Any questions at this point before Mr. Marr continues? Okay, seeing none, back to you.
My recommendation for the committee for this draft is to include fields for the cryptographic keys of the holder of the certificate. And that would include two things. It would include the key for signing and the cryptographic signature itself. The third thing, of course, is the certificate, which is common to both people. That's my recommendation. What this partially solves is, and the reason why it's really important, I believe, to be put into the statute rather than leaving it to a ruling, is because it's really important to get this right and not leave it to decisions after the fact where it can be lost or missed or something. And it is how we affect a demonstration of principal authority, and it allows for much greater things, which is attestation about assets and things like that. That's all I have to say at the moment. And actually, well, I'll just, that's probably enough for the committee at this point. I can go on.
Mr. Chairman.
Yep, go ahead.
And Mr.
Representative,
Chairman,
go ahead.
so Mr. Marr, just to summarize, you're saying if we don't fix that problem, then instead of creating value with this piece of legislation, we might actually create a loophole so that people who aren't the actual owners of something, of a digital asset, can pretend to be. Is that what you're saying, that we need to close this loophole in the draft? Is that the gist of it?
Absolutely.
Go ahead, Mr. Marr.
Yes. Oh, thank you. Absolutely. Representative said, you absolutely need to close the loophole. Now, what closing it in that way by adding those two things for the holder of the certificate, the field for the public key and the corresponding signature. What that does not close is the additional things that you will need to solve down the road. And these were things that I got to in my public testimony yesterday regarding the Dow Working Group and digital identifiers, which is, you have the signatures, but you haven't really, defined a place or a field to hold what blockchain is it on. I don't know. You have some signature. That's really wonderful. A signature and a public key is a great place to start, but it's, where's it signed? You haven't defined that, right? So where is that digital identifier? What's it pointing to? But maybe we don't need to solve all this right now. It might be too much of a tall order. We should work with what we have. And my recommendation for the group at the moment is to include the fields for the holder of the certificate, being the public key and the signature, and knowing that we're going to have to do some additional work in the future. And I am sure Christopher Allen has many, many more things to say here. Thank you very much. I'll take any questions if they're needed.
Thank you, Mr. Marr. Any questions for Mr. Marr at this time? We value that. Those are good points, and it seems like that's the way it would have to happen if it were going to happen, because it is fully insufficient without. But adding that to the legislation to clarify that we'll have to have the public key, cryptographic signature, and then, as we discussed yesterday, we could have a locator address as well as a part of that if we want, if we didn't have it internally stored but wanted some sort of a remote pointer to whatever the address of the digital asset is. That might be a valuable component. I guess that could be optional as well. But certainly the public key and the cryptographic signature of the digital asset, as reflected by that public key, we can incorporate. And again, I think that, Mr. Marr, were you anticipating that to be on page 3, looks like paragraph A, and then it could either be part of Romanet 1 or really a new Romanet? I guess I'd probably do it as a Romanet 3, a new Romanet 3, and then move the Romanet 3 down. Is that what you're contemplating?
If you could, I'm not looking at that page right now.
Oh, that's all right. Page 3, 34, 29, 203, paragraph A. You've got a series of Romanets about what the application shall contain. And we'd want that. And then we just need to note that that was also part of what was stored, I guess, as a necessary requirement for storage.
The 3 Romanets regarding application, I think that's what you're referring to.
Yeah.
Yes, yes, it's there, and you would probably want to make a reference, I would imagine, in the amendment section. When you're amending, or I should say, amending and or transferring control, right? That's in the next Romanet, so you're going to need to change that as well. Make a reference. Yep, I'm not really sure. I'm not looking at it right at the moment, but there's going to need to be a little change there, I believe.
Yep. Agreed. I see what you're talking about. Thank you. Thank you, Brendan. Appreciate any further questions for Mr. Marr. All right, Mr. Allen, back to you.
Yeah, thank you. So I guess I'm more reluctant than Brendan is to put more of this into the law side of things instead in the rule side. So let me explain a little bit of what's going on. First off, there was a question of where does it come from? Well, the W3C has made and has certified and made final DID 1.0, which is now an actual, it's not just a specification, it's an actual international standard from the W3C it very explicitly starts with DID that says, hey, this is a decentralized identifier. And then the next part is something called the method. And, you know, if that method uses ETH, or like I have a method I registered called BTCR, which is a, you know, Bitcoin record that happens to use, you know, Bitcoin identifiers. So you can register this, these DID methods and create identifiers with that, and they will say, you know, which blockchain it uses, if it uses a blockchain, because there are also self-certified approaches to these things that do not use a blockchain, don't use proof of work or any of that type of stuff, etc. So, you know, if you limit yourself to you know, an international standard for decentralized identifiers or equivalent, this is what Homeland Security has already testified that they're moving everything to. It addresses all of these different types of things, and it addresses some of my privacy concerns regarding sort of saying, oh, well, we have to have this certification that has all of these different things stored and or potentially be part of the public record. There is a history of already where someone has, say, a valuable NFT, and it is associated with an identifier that is lets somebody to know who the person actually is who owns that NFT, and then have that specific NFT owner be specifically targeted. So not just like, oh, whoever shows up, we're gonna try to steal from them. No, they're gonna go, oh, that's $1 million NFT, and we know exactly who has it and where they are and what other things they do, and we're gonna basically target them specifically. So there's a lot of privacy things here where we may need to elide or redact or encrypt signatures, such that, you know, because, you know, what the registrar's office cares about is, you know, can we contact the business entity that is behind this asset in case there is some type of claim about this digital asset as being false or fraudulent or not belonging to, no longer under the control of the original party, et cetera, that we just have to be very sensitive to. And that's kind of moving territory right now, and I wouldn't want to spec it because that's what the DID spec did a lot of. So I mean, my first thing is, you know, it should be a digital a DID. If it's not, you know, there are a limited number of self-certifying identifiers, Ethereum being probably one of the most popular, because then you can do pretty much any Ethereum asset, ERC asset, NFT popular today could use a self-certifying asset, and literally giving somebody the identifier actually provides all the registration in it. It's like the identifier self-certifies, you know, all the information that the Secretary of State needs. They don't even need the rest of it. And if you say, yeah, if you want to register a digital asset that isn't any of the above, yeah, then you're going to need some kind of verifiable credential that basically makes these assertions, and there may be some rules by which, the Secretary of State says, well, we need to have this information, but the public does not need all of this information, and we will elide or redact that particular information such that, you know, people can know it was registered, they can prove that it was registered and signed, et cetera. These are all possible. And, you know, probably not for $243,000 or whatever it is, the quote is there, but, you know, for a very reasonable number to do it right. But what I don't want you to be locked in. The Secretary of State who's coming in may decide that, hey, you know, they want to go full bore on this and go, work with Homeland Security and British Columbia, who's also using DIDs and things of that nature to do a bang up job and do this right. Or maybe they just want to do it minimally. You want to allow them to have that kind of flexibility. Just to be, again, though, to be said, I do think in other places we ought to start getting clarity on, like I use the word control. You know, there's also the word principal authority, which more has to do with people and organizations. as opposed to control over digital assets, which is already in the existing digital asset law. So I do think we need to, clear some stuff up here, and Wyoming's the best party to do that. I don't know if that was helpful. I just, like I said, there's just some complexity here. What I want to be able to do is I want to be able to send a DID to the Secretary of State that has say references a digital asset, or I want to be able to send them an address of an NFT, demonstrate that I have control over it, and if it doesn't self-certify, be able to provide some type of signed claim to the Secretary of State to meet their minimal registration requirements. And maybe one of the things the bill needs to have in here, which is, maybe it doesn't specify that the Secretary of State needs to evaluate which of this information needs to be public record for the protection of the people registering. So hopefully that was helpful. I'm available for questions.
Thank you, Mr. Allen. Any questions for Mr. Allen? Go ahead, Representative Western.
Thank you, Mr. Chairman. Mr. Allen, so I want to make sure I understand what you're suggesting. So you're saying that, okay, if you can submit a DID in an acceptable platform, that's fine. That's it. That the Secretary of State's that's all they're going to require. But if you don't have a DID, this is the additional criteria that you have to meet in order for this to be registered. Am I understanding that correctly?
Mr. Allen?
That is correct. That is correct. And there may be some other things that are between the two that their ruling should be able to say, yeah, this does meet a self-certifying requirement, but it's not a DID. It's pretty trivial, for instance, with an NFT, which is not a DID, with an NFT to put in some extra information and some fields in there such that it's self-certifying. So the only thing that you would would need to be is the proof of control, which is easy to do. So they may decide that when they roll out on day one, that tween case they don't want to do. And they'll hold that off until 2023 or 2024. But they should have some flexibility for those types of cases. There may come someday where all I do is I present you a hash and a special high privacy verifiable credential which they can verify, and that would be considered valid, and it would be very, very, very private thing, a very private digital asset. And only when a chancery court comes around would the asset holder basically be able to prove that that thing I registered actually was mine. I mean, I can basically prove that it was controlled, and then at the chancery court prove that it was controlled by me. And that might be sufficient in a lot of these cases, but those are advanced. I want to get the Secretary of State to do the easy one soon and get the ball rolling, and then have the flexibility as they add these other kinds of identifiers or ways of proving control or the registration credential and the privacy of it. They can deal with that as the need comes up. And that's where some of that money, I hope, that comes in, the up to $400 per registration will be used to help fund, allowing for more kinds of digital assets to be registered properly and protect the privacy of the holders of those digital assets.
Thank you, Mr. Allen. So one concept that we need to get to probably to implement this is when Deputy Wheeler was discussing the $284,000, as you know, that's basically adding some fields to a database that they currently have in existence, where if you have those fields propagated, you would have a sufficient registry for digital assets. Mr. Marr provided two additional fields, what is the public key and what's a cryptographic signature on the digital asset that you can also store, and then maybe a pointer to that digital asset, which really it's a pretty good registration in a standard database if you're going to use a standard database, which is, as we all agree, insufficient. But that's what we're going to probably start with. I think what we'll need to think through is a way to write this so that it can be written to the Rolls-Royce model you just described with an appropriate digital identifier and, countersigned authentication, everything that we would want to see in a robust system as we move to that system, and hopefully we find a way to get there. But write it in such a way that Mr. Marr's version is also going to be acceptable, because I don't know that, and maybe honestly, maybe with a digital identifier concept as you're providing, maybe there is a way to put that into the system that currently exists. I think we'll just need to work on combining the concepts. You're not saying anything obviously different from what Brendan's saying, in some sense, of having the public key cryptographic signature concepts, but you're generalizing it to a much broader platform. And I think that's the right way to do it. So we need to figure out how to write this language for what we're asking for in language that allows it to be done within the specific system, which would probably look a lot like what Brendan just said, but reflect that the aspiration is what you're asking for, where if available kind of concept, because as soon as we get a system online that allows us to appropriately engage in digital identifiers, as we've talked about with corporate filings, registrations, and everything else, everything you said just becomes very, very straightforward. But I don't want to hold this legislation back because we don't have that product in place yet. And I'm not saying we need a solution right this minute. You know as well as I do how this needs to go. In fact, probably better than I do on how we could structure that language. Quick thoughts on that, and I think you're obviously right on what you're asking for. Go ahead.
Yeah, I think we made some progress where we were saying that that there needs to be a proof of control. So if you have an identifier and it doesn't auto proof of control, you need a proof of control, and then you need to have some kind of some type of credential that basically says, I am submitting this, and along with I control this, and we're done. In some cases, that can be, as I said, just be automatic. I'm just trying to maybe get the tech out of it and say what the office really cares about is that the asset actually is owned, and that can be self-certified. So maybe you add in the requirement that it has to be self-certified, and there are going to be certain things that can't be, but that may be good enough, because it'll be 80-20 rule. It might even be 99-1 rule that only 1% can't self-certify in some fashion. And then the registration should be one of a number of credential formats that are signed that they just paste into their record. And that registration needs to be able to allow the registrar to do their duty, which is to be able to report to the Chancery Court or whatever that it was duly registered, and they can do that with the certificate that they've issued. So we have two certificates, one in, one out, an identifier. They click, they verify, it's registered. And not try to sort of say, well, what about futures with multiple signatures? And what about futures where we need to redact certain information and all that kind of stuff? If we keep it above the public key level and really define the requirements, I think that'll solve it.
Okay, we're going to look to you to work on exactly what that language is then as we move this along, and we'll probably have to work on a little bit of Romanet 2, and then in the transfer concepts, I agree, rather than being kind of technology specific, being technology neutral, but getting at what the key underlying information is, where demonstration of control works great. We can just say, capable of demonstrating control is going to work in all circumstances for that property ownership. That's how we define it in digital assets. So we're okay on that space. Getting to the identity side is probably the next thing we have to work through, what the language is there. That's what Brendan's getting at with public key, as well as the cryptographic signature is really both authenticating the asset and authenticating control over the asset, but we would need to, we can separate those two concepts. All right. I think we've got a little bit of work to refine that, but we appreciate understanding better what the challenges are there. Any further questions on this select committee? All right. Thank you, Mr. Allen. We'll figure out how to wordsmith
Thank
that
you.
a little bit better.
I look forward to working with you.
Absolutely. We'll rely on it. Thank you. Okay. Any further public comment? Anyone else online? All right, Brendan, very, very briefly. We're behind. Okay. Let's get to Brendan very, very briefly. Brendan, 1 minute. Where are you, Brendan?
Yes, my brief comment is I agree with everything that has been said, but my additional comment is these are the kinds of things that will, that self-certifying part, right? That proof of the entity being a valid entity in Wyoming jurisdiction, that pegging. These are the kinds of operations that need to be done with the registered agent. And at some point to scale to, billions of these things, this process of validation will need to be done on the side of the registered agent. So I urge the committee to be thinking about that as we go forward. That's all I have to say. Thank you.
Thank you. That registered agent concept is something that I think we need to integrate into it. Thank you for that, Brendan. Mr. Pope, hello, welcome. Please introduce yourself and appreciate having your input.
Thank you, Mr. Chairman. I'm David Pope. I'm a CPA, though I'm here completely as an individual, not representing any organization. And I'll make it quick and brief. First off, I apologize for my appearance. I was down working with the horses and actually ran up because I'm very interested in this topic. I echo Mr. Allen's concerns about privacy. Digital assets encompass a wide range of assets as opposed to a trademark, which is a fairly well defined asset and usually associated with a particular brand, brand or company. Digital assets can be works of art, digital works of art, even physical assets that the token has a right to. And as such, I think that developing a way to keep the ownership of that asset a private thing would be what I would recommend, mainly because tracing ownership back to a company or an individual of any asset should be not as easy as looking it up on the Secretary of State's website. And my thought was a new form of or a new possibility for registered agents to track ownership changes and to track ownership itself. With that, that's my comment on it. It also seems to be a heavy load for the Secretary of State's office to continually be tracking ownership on an asset that can be electronically traded. So distributing that particular function and privatizing that particular function, I think may not be a bad thing to do, especially for economic growth within the state. And that's my comment.
Thank you, Mr. Pope. Any questions? Go ahead, Mr. Co-Chairman.
Mr. Co-Chairman, Mr. Pope, do you know, I know that in Delaware, there's a pretty robust registered agent industry. Do you know if this is what do they have anything similar to this in Delaware? Or to what extent is it privatized in Delaware? Do you know?
Mr. Chairman, if I may,
Yeah.
I don't know of any sort of digital registered agent within the state of Delaware. I don't know if that exists. I think it may be.
Oh no, I'm sorry. I don't mean digitally. I mean just in the in the system that exists now, are there any privatized functions of the registered agent in Delaware?
Well, the privatized functions rest with their version of the commercial registered agent, like we have here. But beyond that, as far as a particular registry of assets, I don't know.
Any follow-up, Mr. Chairman? All right, thank you, Mr. Pope. And this is something certainly that Mr. Allen has been talking about for a while, is trying to integrate digital asset management into what our registered agents are capable of doing, and adding some new features, I guess, to what they're capable of doing. And this might be a time to start going down that path. I absolutely agree with what you said, what Mr. Allen said, that we need to be able to build in privacy while also having the appropriate ability to track through, as we do with registered agents. So this is probably the mechanism that we'll need to use. Thank you for bringing that to attention.
Thank you, Mr. Chairman.
Any further public comment? Yep, come on up. Yep, appreciate it, thanks. And again, introduce yourself for the record.
Name is John Six, founder of Space Dial LLC. I'd like to expand upon what Mr. Allen and Mr. Pope spoke about privacy, and the way to accomplish that is with zero knowledge proofs. And that's the way to expose the truth of the statement without exposing the contents of that statement. And then I'd like to expand upon the toolkit being developed where proposed by Secretary of State, having indexing mechanisms to be able to search these digital assets. And then it'd be also interesting to have an API to deploy DAO LLCs as well. So
Thank you. Any questions for John? Seeing none, thank you. Appreciate it.
thanks.
Further public comment at this time? No more online. Seeing no public comment. Public comment is closed. Back to the committee on this bill. What committee thoughts on the legislation? Obviously, we've got a little bit that needs to be done. I don't know if anyone feels comfortable we can do it now, or if we want to move this to the next meeting and address some of these concerns. What's everyone think?
I think we amend the bill and move to the next meeting.
Yep, sounds good. Senator, which amendments or anything in mind that you want us to be working on during the time between now and the next meeting? Okay. So registered agent concept, I think that is one. We need to make sure without objection that rather than having what we have, I guess, on page 3, Romanet 1 under the paragraph A, the name and address of the person applying for registration. Actually, that might cover it, but maybe we just need to be explicit. If the person is applying, it doesn't necessarily mean that they're the owner, but we probably, nope, that's not accurate. Romanet 3 says a statement that the applicant is the lawful owner of the digital asset. So we need a circumstance, we need to make sure that the language reflects the possibility of a registered agent. And for now, we can just go with registered agent, and we can change that later. So when we're referring to a registered agent here, we would be referring to what we're statutorily referring to as a registered agent. I think as a starting point, we don't want to reinvent what a registered agent is.
Representative Stitt?
Yeah, Representative Stitt has problems with that. Thoughts?
Broad brow.
Mr. Chairman, I think that the function you're trying to achieve is just that the person submitting the application might not themselves be the owner of the digital asset, but they might be acting as an agent of the owner. Is that the idea that you're getting at?
That's the idea. The concern I have with only saying something along those lines is the insufficiency of the requirement of responsibility by that agent. If we say registered agent, I think we get to bring on board all of the obligations of a registered agent, perhaps, and maybe we need to think through some nuances of that, but there's a responsibility. Go ahead, Senator.
Representative, if it is just not the person filling out the application, what then?
Mr. Chairman, I guess what we're trying to prevent, I I think we're just trying to achieve the functions that this is a legitimate filing, that the person doing it's really authorized to do it, that the person they say the owner really is the owner, and that we have some safeguards about that. I think that's the function we're trying to achieve. So I don't have any particular, you know, and then right. So I don't have any particular language, but if we achieving that function is fine. I don't know that the word registered agent itself does all that much for us, because what a registered agent does is just agree to be there to accept service of process when you get sued. And that's basically all they do.
I think that's a point, though. I mean, if you just say that if we pass this with, you can act as an agent, I would raise my hand with no obligation and say, I'll be that person. I'll just take $1 on every transaction. I don't care who you are, what you do, whether you exist or not. And I would expect full 100% anonymity. We can go that route. If we're going to go that route, though, we don't need anyone acting. We can just say it's okay to file privately, because there's nothing from a technological standpoint that precludes a fully private filing, even with a signature. If we want these to be registered in a way that we know who registered it, then we have to think through the system so that you can have both anonymity and a way to know somehow. We could build a new one. I was hoping we didn't have to build a new one. I was hoping we could go with registered agents, because it's done that before.
It's the same, it's conceptually the same.
Yeah, I think it's conceptually the same. And to the second part of your analysis, I believe the Secretary of State's office does have authority to maybe not the authority we necessarily want them to have, but they have statutory authority, I believe, to go and seek certain information that's already held by a registered agent that's not publicly available, because a commercial registered agent has to maintain certain information about their officers and directors that is not made public to the Secretary of State's website. And
right.
So this is very similar.
That
structure is already there.
Correct. I think that's the intent of using a registered agent, and we might have to go into the the registered agent statute and provide that little tweak, but I think that's easier than constructing something new that accomplishes the same thing. Any thoughts?
But we would need, yeah, the one thing I'm unsure of is exactly what the teeth are on their ability to, on the Secretary of State's office's ability to request that information. That probably needs a review by us in general.
Do you mean with regard to standard registered agent with LLCs and with anything else?
Yeah, if we're looking at it as from a mirroring standpoint, we might as well.
We might as well.
Mhm.
Okay. All right. So this is, all right, this is a change. Then we want to make sure that we allow for a registered agent to register on behalf of the lawful owner a digital asset, however else we're doing it. So that's something that we need to incorporate.
Mhm.
And we can take a look at the teeth that are behind that on how we might actually get that done.
So,
Representative
Mr.
Schiff.
Chairman, could someone walk me through an example of, let's imagine that the owner of the digital asset is an LLC. Okay. Is the only person who's going to be able to to actually do the application the registered agent, or can the president of the LLC or someone who says, I'm the managing member of the LLC, I'm doing it? Someone has to hit the keystrokes to actually punch this in and be the human being who answers the phone if the Secretary of State has a question, right? I mean,
You would have to have the sophistication to control and authenticate. So anybody that had the sophistication to control and authenticate would be able to do that. Which again would be incumbent upon the relationship between the registered agent and the entity of the LLC. If the LLC is the owner and has the control and can identify as the lawful owner, they would be able to take action. In that circumstance, though, again, based on most of the ways that this would operate, if you did that, you would probably be disclosing, you'd be piercing the veil. Yeah, you'd be disclosing, you'd be piercing your own veil.
You'd be signing on behalf of yourself.
Right. You might not want to, but if you had control, you have control. So you'd be able to. And that's fine. I mean, that's consistent with
What you can do now.
with what you can do with digital assets. If you've got the control, then game on. All right, so we'll have to work through that. And then I think the other amendment, well, let's see, walking through the legislation. Yeah, that was what we were just going to look at. On page 3, we had a lot of discussion about how to structure what's being asked for. And so we need to rework the Romanettes there on under paragraph A to get to the point where we're talking about a digital identifier and control. And we'll work then with Mr. Allen, Mr. Marr, and try and get to the point where we believe we have the language correctly so that it reflects best practices. Again, technology neutral, all the kinds of things that we are always doing, but trying to get to the right threshold with the appropriate phrasing and recognizing that we understand that it needs to work not just with the current system of the Secretary of State's office, but with what we envision to be a potential future system. So we can work through that. Well, on page 4 first, page 4 was where Deputy Wheeler discussed the idea of whether they want to review or automate. And I don't think we can do a review process. So I think coming up with an automated review or a non-review, effectively an automated process, and we can put in that may provide guidance for conflict or something along those lines. Make sure that we have a may though, so that they don't have to, but they're able to. And at that point, that would give us the ability to use something like AI or an automated engine that provides feedback on you might be conflicting with this, but we'll just take out the process of review and let everything go through and be registered. Let's see. Senator Cost, what were you noting? Oh, yeah. Let's do that. Consistent with Deputy Wheeler's recommendation, page 8, line 24, and on 23, I guess, in whole or in part, strike. On page 12, effective date, Deputy Wheeler requested October 1st, 2023. If everyone's comfortable with that, without objection, let's go with that. If we come up with better ideas, we'll do it differently. But for now, I think let's go with what's possible. And the one thing that I'm not sure whether it needs to be reworked or not, but based on the digital identifier concepts and the concepts we discussed back on page 3, we may need to conform well, I guess honestly, pages 6 through 8, we may need to conform, and I guess just conforming is going to be fine. All right. So those are what I've heard as the amendments that we need to go forward. Go ahead, Representative Stith, thoughts?
Mr. Chairman, just to clarify, so on page 3, line 19, where it now says the secretary may cause the application to be examined for conformity with this article. Are we suggesting that automatic filing is the default? That the secretary shall allow automatic filing, or in the event of substantially non-conforming application may cause it to be examined? Is it something like that where the default is that it shall be automatically filed? Or do we make it just permissive for the secretary to either allow automatic filing or to review it if they so choose? See the difference there?
Yeah, I definitely do. And I guess I'd be inclined, for clarity's sake, to just say there is automatic filing. And maybe we just leave the may off, which if there is automatic filing, that nothing would preclude them from flagging conflicts if one comes up that they see, but they would still automatically file. That's certainly cleaner and takes away any onus for them to make a mistake or not to follow through on obligations. What are your thoughts on doing it that way? Are you comfortable with that? It's cleaner. All right, let's do it that way. So forget the may clause. Okay.
Mr. Chairman.
Go ahead, Representative Yan.
Mr. Chairman, I'm trying to mull over the registered agent part again. My apologies. But if we have that idea that a registered agent could be the applicant, but as well as require a cryptographic signature and or certificate that verifies essentially cryptographically that the applicant's also the owner of the digital asset. Okay. So I mean, I'm just worried on how those two concepts would mesh together properly.
Ask that again. I'm sorry. I don't know that I was.
So if I recall correctly, Brendan Marr wanted to ensure that there was cryptographic proof in the application to ensure lawful ownership. Well, not to ensure lawful ownership, but to ensure cryptographic ownership of the digital asset. How does the registered agent? Is the registered agent the one required to make that signature? Because then they would have to have control of the private key, or they just get a signature from the owner who gives it to the registered agent who applies for it.
Well, so I think there's probably multiple ways to solve that. You could, I mean, and maybe that's through multi-signature authority. That's something that I don't know that we need to be explicit about how the owner and the registered agent would interact. I don't know that we have to say how that would happen, but if a registered agent is coming along and having the authority to act on your behalf, somehow you've had to figure out how you're comfortable with that registered agent acting on your behalf to register the digital asset. And I don't know that that's a problem we have to solve.
Yeah, Mr. Co-Chairman, I think I think we can, if we want to, have a requirement that's similarly. I think of something at a very basic level, like obtaining an EIN. If an attorney obtains an EIN from the IRS on behalf of their client, the IRS requires a specific form be filled out and completed in advance as proof and you don't have to give that form to the IRS unless it's ever requested. But the purpose of the form, I suppose, from the attorney's standpoint, is like a CYA. Is ultimately what it is, so that if someone ever said, hey, I didn't give you my social security number, you didn't have permission to go and get an EIN. I think that, to me, that's the only piece that might have to be worked out of what Representative Yin is discussing, because I think it would be privately figured out between the registered agent and the person seeking registration. They're going to have to provide that. I would not be opposed to something similar. And the other example would be an LLC. The registered agent has to sign a form of consent as well, saying, yes, you can use me. So, I mean, there's different pieces in there where you want to make sure that there's some documentation that there was actual consent for that registered agent to have that authority to register, because what you don't want is registered agents out registering the asset when they don't have permission to do it. You want that, but I don't know that you have to prescribe the process, just a simple form where the person signs and authorizes it. And they keep it privately. It's not like the consent to registered agent, which is publicly filed. It's more like the IRS EIN form. It's held privately unless it's ever compelled to be given. And then I think to the applicant issue, that seems to me like that's just on the Secretary of State's system. It's going to have a drop down box that essentially says, are you the applicant yourself, or are you representing the applicant? And that gives the distinction between the owner not being the actual agent. I mean, we already have that issue with, on a complete tangent, we already have that issue with LLCs where I don't know what portion of the public believes, but I've dealt with people who believe that the person who filed the LLC is the owner of the LLC. Been dealt in lawsuits with people who thought they legally owned an LLC because they were the ones that organized it, and it doesn't make you the owner. So I think logistically we have to make that clear on the filing. So, but so I don't know what you think about that, Representative.
And I think this is something to explore further in conversation and look at what reasonable technology solutions maybe we can recommend and provide guidance for that type of circumstance. Getting back to what John said about zero knowledge proofs. I mean, I think there are ways where technologically I could demonstrate that I'm representing the owner. So I could cryptographically represent that cryptographically demonstrate that I represent the owner of a digital asset without disclosing the owner of the digital asset. So that's like second-hand control. Now, that's getting into tech solutions, which we probably need to get into. I don't know how we put that in the database at this point in time. We probably have to talk that through, but it's doable.
It can also just be a piece of paper.
Or a piece of paper. All right, go ahead, excuse me, Senator Costa.
Thank you, Mr. Co-Chairman. My question, I guess, I'm looking at it from the same perspective. Okay, what's our goal to what we're trying to achieve here? Is it that the owner or whoever is signing it has had permission? And if so, I think it's only fair that we have some documentation that says the owner gave permission or the owner is the one doing it, rather than, well, it's understood, or well, it'll take place and we'll be okay because they had some access to the key or whatever. I think it's important that we don't put anybody, I'm thinking the Secretary of State, don't put them in a position where they're kind of up against the wall as to what's happening here. I think we got to make sure it's clear.
Yeah, and for the direct ownership, that's pretty obvious. We'll have to kind of think through and talk through the indirect ownership and make sure that we have a good plan for that. But I still think, I mean, from a functional standpoint, the case that we need that is certainly accurate. If you have a high value digital asset, you don't necessarily want to put your home address and name. That's just not viable, particularly since they're so easily transferable if you don't know if you've got access to the public or the private key. All right. David, questions?
Mr. Chairman, so who would I be looking to as far as finalizing some of these? Will it be the two of you?
Yeah. Anyone want to jump into this? Feel free. Clark, you want to jump into this?
Be happy to, after November the 8th.
Okay, after November the 8th, Clark wants to review this document. So November 9th, Clark would like to. Representative Stith is very interested. Yeah, honestly, all of us.
Mr. Chairman, there is one thing missing from this bill.
Go ahead.
On page 2.
Uh-huh.
We provide a certificate. We provide a certificate. What I think is really unique is that the certificate, may be attached to the registered digital asset or otherwise associated with it. But I just think if it's going to be attached to the digital asset, it ought to look good. So
you're suggesting that as part of it, it have incorporated into whatever our signature is, perhaps a steamboat?
Yeah, I don't know. Yeah.
All right.
Perhaps something like a bucket rider.
Yeah. All right, that's gonna be fun to figure out how to do, but I don't see why we can't. As part of our signature,
I mean, if,
Yeah.
I'm sure that the folks out there, the technologists can figure that out.
we should have had that as a challenge for the blockchain stampede, the hackathon.
And good.
Yeah, we'll look to our experts. We'll find a way to sign everything with the bucking horse and rider. Looks like Mr. Allen has suggested that he can do that. All right, there we go.
That easy.
We're good. All right. Any further concerns there? We're all going to work through this one. Good. Then with that, on to our next topic. Is it a break time first? It is a break time right now.
Not a bad idea.
Yep, it's break time. Back at 4:10, please. Let's take a break until 4:10. All right, and we're back. 4:12, that's as close as we've come, I think, to being on time. I feel good about it. Yes, we are. All right, so the next topic for our discussion today is, I think, going to be very brief, which is good since we need something to be brief. Digital asset amendments. This was on our agenda, and this is staff in the Legislative Service Office. We've got just a quick little bit of discussion on that on the overview, or should we go straight to disclosure of private keys? I don't remember whether we were going to hit on digital asset amendments separately or not. Yeah, that was kind of where I think we left it. So we had, and just for the edification of the committee, we talked through, pursuant to our last select committee, whether there were language changes in our digital asset definitions. So we had the conversation, you'll recall, last time with Mr. Lindholm and Mr. Land about the federal legislation that they're bringing forward, and they have definitions of digital assets. And we wanted to take a look at their definitions and see if there was room for change with our definition to conform. They were similar, and then they made some tweaks to them based on some of the things that were going on at the federal level. And we're not, there was nothing that appeared valuable enough to retweak our tweaks of their tweaks. So, and can we get Senator Nethercott would like to tweet that tweak? Are you good with that, Representative Western? So the take-home answer is really nothing there. There's no there that we know of yet. Okay. Anything on that? Good. Perfect. And honestly, I'm not entirely sure why we had Deputy Wheeler. Deputy Wheeler, would you like to speak to that? Good. Excellent. With that, then let's get to our kind of final agenda topic, the disclosure of private cryptographic keys legislation that we've considered a number of times before, and wanted to revisit. Senator Nethercott often dislikes this legislation, and we hope she loves it this time. At least it's a short bill. So with that, let's quickly run through the bill. Many of us have seen it before. Mr. Hopkinson, floor is yours.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 23 LSO 58 Working Draft 0.5 Disclosure of Private Cryptographic Keys. For some little bit of history, this has been before this committee before. In 2020, it was run as House Bill 41, failed introduction, and in 2021, Senate File 105, where it died in the Senate Minerals Committee. Some minor differences in this bill versus ones that have been previously run. But what this bill draft does is just prohibit a court from requiring the disclosure of a private cryptographic key in any civil, criminal, administrative, legislative, or other proceeding that relates to a digital asset, digital identity, or other interest or right. Digital identity is new in this version. So it prohibits the disclosure of that key unless a public key is unavailable or unable to disclose the requisite information with respect to that digital asset, digital identity, other interest or right. Subsection B is just there to clarify that this is not interpreted to prohibit any lawful proceeding that compels the disclosure of the actual asset, et cetera, so long as they're not required to disclose the private key itself. Section 2 then, this is slightly different. It just is, and what it's doing here between section 2 and section 3, which is repealing 3429-103E3, that simply is the definition of private key. So this is just moving it out of a subsection in this title and moving it up into the definitions section. So it's not changing any of the law, just kind of changing where it's located so that it is applicable to this new section. And with that, I would stand for any questions on the bill draft.
Thank you, Mr. Hopkinson. Any questions? Go ahead. Representative Stith, I see you down there.
Mr. Chairman, we have seen this bill a time or two before. So to refresh my recollection, Mr. Hopkinson, can you walk me through an example of how this operates? Let's imagine that I'm getting divorced and my spouse owns a house and a Bitcoin wallet that's got a lot of money in it. Okay. And the judge says, awards the house and the Bitcoin wallet to me. Okay. and my spouse refuses to sign the deed to the house, no big deal, because the judge can, by judicial decree, just deed it over to me, say, regardless of what the spouse does. With the Bitcoin wallet, how does it play out? My understanding is you have to have the private key to actually exercise control over the digital asset. If the person can never be, how does this play out in that family law context, for example?
Mr. Hopkinson.
Mr. Chairman, Representative Stith, it's my understanding the court wouldn't be able to order the disclosure of that key itself, but it could still order your spouse to disclose or to transfer those Bitcoin assets to you. And then remedies there would be in line with what they would do if she didn't turn over the house, contempt of court, those sorts of things that could be applied.
Mr. Chairman, Mr. Chairman, so contempt of court then
Go ahead.
becomes the solution to it. Okay, and then in the criminal context, I guess same rule applies, I suppose. If they can be held in civil contempt, I suppose, and locked up until they provide the key. Thank you.
Thank you. Any further questions? Further questions about how this works before we go to public comment? All right. With that, let's go to any public comment that we have. Public comment in the house or online. We have online.
Yes, Mr. Chairman, we have Brendan Marr and Christopher Allen.
Okay. Let's go to Mr. Marr first. And to both Mr. Marr and Mr. Allen, as they're coming on, you can let them both in, by the way, which is just fine. I will note that we're already past our official departure time. So we have been through a lot of this before. Let's kind of hit the highlights and try to keep testimony to 3 to 5 minutes if we can. Thank you.
Yes, everybody can hear me?
Yes, we can.
Is that a yes? Oh, great. Oh, great. Yes. My name is Brendan Marr. As I testified earlier, I'm on the Digital Identity Working Group and several others. The salient point I'd like to make is that it is worthy to note that when it comes to this idea of private keys and court orders, things get a little bit more complex when it comes down to keys that are stored in HD wallets, high definition wallets, and even more complex as they may be related to businesses that maybe they store and have transactions that are related to different public keys that are in different hierarchy of the wallet. Who knows what people will do and how they will structure things, but there's a lot to consider in these regards in terms of good practices and bad practices. And I just want to raise that to the committee that there'll be more to think about along those lines. That's all.
Excellent. Thank you, Mr. Marr. Appreciate those comments. Any questions for Mr. Marr? Any questions? Seeing none. Thank you, Mr. Marr. We appreciate that. And we appreciate your continued engagement in this. And with that, Mr. Allen, welcome. And back to you. You are muted, Mr. Allen.
Thank you. So appreciate you inviting me to continue offering testimony on this subject. I'll keep it short. I published an article on my blog at blockchaincommons.com, which was also picked up and published as a guest editorial on Bitcoin Magazine, and was highly received, and lots of people commented on it on Twitter, and I've gotten additional people involved. There were 7 key points in the article. I'm not going to go into the details of them. Private keys are not assets. So when the other legislator said, go to jail until you reveal the keys. No, you go to jail until you transfer the asset. You have to. I mean, it's you have to transfer the asset. That's what the lien is against. Private keys are not the proper tool for discovery because they're not physical. Private keys serve lots of purposes, many of which may not be under the action of the court at this point. Courts are just not protected by prepared to protect private keys. We have testimony from Beth Buchanan, a former prosecutor, federal prosecutor, to that case. Courts are by forcing private keys to be revealed or prematurely disclosing and possibly allowing for people to do fraudulent activities. Signing, it requires private keys that without proper consent. And we have to be more demanding of digital assets than we are of physical assets. So we've got a number of quotes from people. John Callis from Electronic Frontier Foundation says, hey, they don't really want the key, they just want the data. Asking for the key is asking for the filing cabinet rather than the file. So, I mean, I have other quotes like that. And then we just received today, Chairman Rothfuss, do you want me to read the 2 paragraphs from the letter from Block, or do you want to read it, or save it for next session? Okay.
Well, I think Mr. Allen, that we have that letter in written word. We can make sure that it's again circulated so that everybody's got it and can read it, so that would help expedite if we just hit the kind of key concepts and high points.
Sure. I mean, the basic thing is there also, the Block is the new name for the company called Square, which is a major international financial corporation, or really allowing for small businesses and individuals to be able to do a lot of different things that the big banks weren't allowing them to do. And this was basically a strong concern because they are beginning to play around with Bitcoin and other digital assets that they agree that private keys need special protection. So I'm hoping in future sessions we'll be able to get more organizations from around the US to also testify. So finally, I just wanted to close with the new points that the LSO offered in the legislation. There was one thing that bothered me just a little bit. As I've expressed in previous testimony, trying to be careful to address the future that is constantly changing by not prescribing a specific way of doing it. And I've always felt that the or any substantially similar analog in the definition of private key addressed a lot of the different issues there. I agree that for the Chancery Court, they'd love to know and have more codified what other analogs are substantial, but there are emerging things. The one word in here that got me a little unclear was it says held by a person. I just wanted to make sure that that person could potentially be a corporation, because there are situations where a corporate person may be involved and compelled, where the risk to the private key could be to the corporation, all the stockholders, all of the other parties. And so as long as it means both kinds of persons, I'm fine with that. But I just wanted to make sure that when you're reading that language, that it's clear. That's it.
Yeah, Mr. Allen, appreciate that last comment. We have to go to kind of great lengths to not indicate that it means a natural person or a corporation. So it's pretty clear in our statute that word person will contemplate the circumstances that you want it to contemplate.
Thank you.
Any questions for Mr. Allen? All right, thank you for your work on this, and thank you for the article. I know that you circulated that with us in the Select Committee, and we appreciate the work that you've done there, as well as reaching out and trying to get additional feedback and develop interest in this topic area. Any further public testimony? Anyone online? Late in the day? Anyone in the room have any thoughts? We are on the bill. So this is 23 LSO 58, disclosure of private cryptographic keys. Any public comment on that? All right. Seeing none, public comment is closed. Back to the select committee. What is your pleasure?
Move the bill.
Bill's been moved. Is there a second? Moved and seconded. All right. Discussion.
Question.
I'm looking both ways. Go ahead.
The question.
Representative Stith, go ahead.
I call for the question.
Calling for the question. All right, that's good.
Wow.
And the answer with no discussion. All right, we've seen it before. Yep. Deft procedural move. The question's been called for.
Senator Furphy excused, Senator Cost,
Aye.
Senator Nethercott. No. Representative Stith,
Aye.
Representative Western.
Aye.
Representative Yen,
Where did he just walk off to? Well, we can hold the vote for him. I think he's coming right back. Excused for now. See if he comes right back.
Co-Chairman Olson,
Aye.
Chairman Rothfuss,
Aye. He better come right back. Let's see. I thought he just walked up. Well, we'll close it. I think we're okay.
all right, marking him as excused.
Yeah, let's
That
mark him
passes.
excused. Okay, thank you.
I would have,
Did what to you? Go
I
ahead.
would have
Mr.
assisted, but my name tag says majority whip.
Yeah.
It's outside of my jurisdiction.
It was just a moment ago. I was looking over that way. All right. That concludes our agenda of business. And with that, we will have an open public comment available, and hopefully those will be very brief public comments. And then we'll get back to the committee for any directives from the committee and motions, as well as going back to staff to review what we need to do. So open up to general public comment at this time. Any general public comment online? All right, John, come on up. Looks like you've got some.
Thanks,
ahead.
committee, for having me. Name's John Stokes. Founder of Spaced Out LLC. I'm here standing on the shoulder of giants. I wouldn't be here without the work you guys have been doing. I started participating in 2019 with the Wyoming Hackathon. And I just want to emphasize how those efforts, bring outsiders such as myself through the technology ecosystem of Wyoming. And I never would imagine I'd be paying rent in a house here in Laramie or have Wyoming license plates on my car. But here I am a year after executing on the Dow LLC and winning the economic impact prize from the state, which has been a huge catalyst for what we're doing on trying to define this emerging space industry and within the context of Wyoming. I have received some advice from former defense intelligence. I guess there's not really no such thing as former, and also the business vice president of business for Virgin Orbit. And their advice to me was to get Wyoming legislature to position itself, position a state to have launch resiliency capabilities. And that would be a major drive for that economic growth. So with that, I would also like to suggest a pilot project that would define certain industry standards within the scope of the development within this committee, such as Web3, and I'd like to bring into the fold, AI and as well as emerging space technology. I think one of the industry standards that I see it, these industry standards being developed through the university and then potentially adopted by the state of Wyoming. And one example I can show is with the IEEE. I was working with them to develop the standards for AI certification, and then that was adopted by the city of Vienna. And the city of Vienna is one of the happiest cities in the world. Maybe there's a relation, who knows? But that's an example of industry standards being created and then adopted from the government capacity side. So I'd like to develop a pilot program that would create these industry standards through the University of Wyoming and then adopted by the state of Wyoming, and one such that I think could bring a lot of funding through strategic financing from federal government for tackling the problems of space debris and defining the principles for regenerative and sustainable satellite design. So that would be like incorporating like gas cap for it to be refueled and things like that, and operating systems that could be maintained and updated. So I guess, yeah, that's what I would like to bring to the table, and also the comments I mentioned yesterday about the public works style. So yeah.
Thank you. Questions for John? Well, we appreciate your engagement and I was trying to think back how many years ago you started coming to these meetings, but we know that you've been a part of this community for years, perhaps 5 years, if I'm not mistaken. And
Yep,
yeah,
2019.
so there we go.
Yep.
Appreciate that, and appreciate your engagement and the fact that you've stayed a part of this community and worked with us on all this legislation is appreciated. I do like the ideas that you're bringing forward. AI is something that this select committee needs to start working on and get engaged with. There's a tremendous amount of policy need there, and there's almost nothing out there among other states.
Especially around the transparency and ethics and,
yeah,
knowing who owns the systems that are being, pushed. So.
Yep. Agreed. Appreciate that. All right. Any further questions, discussion?
Mr. Co-Chairman,
Go
I'm
ahead,
also
Mr.
not
Co-Chairman.
opposed to adding space to the title of this committee.
And I'm not opposed to meeting in Vienna if we have to.
Yeah.
Cool.
Yeah.
Thanks, John.
Yeah.
Thank you so much.
Thanks for having me.
All right. Further public comments? And yeah, let's get a budget on the Vienna trip. Might have to ask. Probably have to legislate that one. Yeah, let's get that worked out.
It could be Bermuda as well. That's fine.
Right. Well, honestly, we probably need Vienna for the space, and Copious is there, and then Bermuda, so that we can talk a little bit about reinsurance banking, and there's some good topics there. Third venue. Yeah, probably here in Laramie. Yeah. Okay. With that, public comment is closed. Back to the committee. I think there's some concepts that the committee is interested in moving forward. So committee, any motions or ideas?
I do have an idea.
Go ahead, Senator Nethercott.
Thank you, Mr. Chairman. Shoot. I move for a bill draft for a similar to our digital securities filing system to that bill, but associated with an NFT regarding public identity. Need a second. And
We've
then-
got a second. Go ahead.
All right, and then this is very, very conceptual, but a working group to be created to work with LSO comprised of me, Mr. Revelle, and some other experts and anyone else who has an interest on the committee.
And by public identity, this is the name, image, likeness type concepts that
Correct.
we're seeing
Yep.
play out, and it would be similar to the registration legislation, as I understand it,
It would be generally, yeah.
Okay.
Will help.
paralleling that. All right, any discussion on that? Okay, we've got a motion to prepare a bill draft for the next meeting on public identity, name, image, likeness, paralleling the registration legislation that we looked at earlier today, and a proposal for a working group to work through that, will be chaired by Senator Nethercott, and Mr. Reville will in absentia be drafted into that. Yeah, he wants to. Well, it doesn't really matter at this point in time. He's not here to defend himself. And I think Representative Yin, oh, well, Representative Yin. All right, Representative Yin's here. I believe Representative Yin, who just suddenly appeared,
We
also wants to be on that one.
we need a representative from the House on that
Yeah.
subcommittee to make
And
sure.
I think Representative Yin's a great choice
Yeah.
for that. He. Okay. Without objection, if there's any objection, we'll vote. If there's no objection, we'll just proceed. All right. Without objection, motion carries. Any further? We don't need a roll call. Any further motions? Anyone else have anything they need? All right, any other business to come before the committee ahead of our next meeting? We'll go back to the legislative staff in a second ahead of that. All right, and then with that, let's go to our legislative staff and see what questions they have and maybe run down what the expectations are from this meeting.
Mr. Chairman, just to briefly walk through the actions the committee has taken. They voted to send 23 LSO 159 open banking to the Minerals Committee for consideration of sponsorship as amended. Committee voted to sponsor 23 LSO 158 decentralized autonomous organizations amendments as amended. Voted to sponsor 23 LSO 49 for-profit public benefits corporations as amended. Committee moved 23 LSO 51, the Stable Token Act, to the next meeting, and allowing for the chairman, the treasurer, governor's office, et cetera, to help and look at some amendments to be provided and incorporated into the bill for the next meeting. Committee moved 23 LSO 171 Wyoming registered digital assets bill draft to the next meeting, again with some conceptual amendments to be discussed and incorporated into the bill draft. The committee voted to sponsor 23 LSO 58 disclosure of private cryptographic keys, and so far has requested one additional bill draft that we just discussed.
That one, yeah. All right, thank you for that. And any other questions, anything you need from us before we adjourn?
Mr. Chairman, I'll just be reaching out to those who.
Sounds good. Perfect. Well, thank you all. I appreciate all of your hard work. Thanks everybody that's been joining us both virtually and in person over the last couple of days. Remember that the blockchain stampede and hackathon is underway, and over the next few days, this select committee has full access to anything that's happening at the stampede. There's the concert on Friday night. So please attend. I'll follow up with you in a moment. All right. And with that,
Mr.
thanks,
Chairman.
Yes. I'll look at
Just-
that under the wire. Wow. Hit it.
Just to mention, next meeting is November 17th and 18th in Cheyenne.
Excellent. November 17th and 18th in Cheyenne. Hope to see everyone then.